I said at the beginning of the conference, for each panel discussion, it centers around a paper that was authored for the conference. It's not the case for this panel. This panel we assembled belatedly in response to significant news developments, specifically the President's designation of Matthew Whitaker as the acting Attorney General upon the resignation or termination of Attorney General Sessions. Now, the purpose of discussing it here today is not so much to focus on the Justice Department specifically, or Mr. Whitaker specifically. Rather, we recognize that the issue, the legal issue, the challenge that was raised against Mr. Whitaker's designation could have massive ramifications across many agencies. Of course, the Justice Department isn't the first agency to have an acting agency head, and it won't be the last. And if confirmations become more challenging in the Senate, not just in this administration, but in future administrations, you could see more presidential reliance on acting agency heads more and more in lieu of quick nominations and appointments of permanent agency heads. And so we moved as quickly as we could to assemble a panel discussion of scholars and experts on these sorts of issues to just have a very general discussion of the issue. Because we assembled the panel so quickly, all the participants haven't had weeks and weeks and weeks to prepare, but we knew that all of them brought to the discussion background and expertise that would make for an interesting conversation. And the fact that two of them are repeat players in the conference today means we actually get to save some time on introductions. If you don't mind, David and Marty, let me first introduce first of all, we're pleased to be joined once again by David RIVKIN, a partner at Baker Hostetler, and Marty LEDERMAN, visiting associate professor at the Georgetown Law Center. They'll be joined by two more scholars you haven't heard from yet today. Sitting to my immediate right, Professor Jennifer Mascott is assistant professor of law here at the Scalia Law School. She teaches administrative law and federal courts. In fact, didn't your class have its exam today? So a couple of our student fellows who are here helping with the event today actually took your exam and then came here to help with the event. In addition to her work here at the law school, where she teaches not just administrative law, but a seminar on the history of administrative law with Justice Thomas, she also serves as a public member of the Administrative Conference of the United States. She clerked for Justice Thomas, and before that for Judge Brett Kavanaugh of the D.C. Circuit. And our fourth speaker today is Edward WHELAN, president of the Ethics and Public Policy Center. He directs EPPC's program on the Constitution, the Courts, and Culture. He writes widely on constitutional law and current events for the Bench Memos blog at National Review Online, a very widely read law website, and other publications. Mr. WHELAN clerked for Justice Antonin Scalia. He served as general counsel to the U.S. Senate Committee on the Judiciary. And from 2001 to 2004, he was principal deputy assistant attorney general for the Justice Department's Office of Legal Counsel. And most recently, he was co-editor of the speech collection, Scalia Speaks, and editor of another, what's the next collection coming out? The new collection of Scalia speeches will be?
The main title is On Faith.
On Faith. Well, thank you all for joining us. The order that we settled on would be Ed WHELAN, and then Marty LEDERMAN, and then Jen Mascott, and then finally David RIVKIN. So Ed, would you like to go first and sort of set the table?
Thank you, Adam. I feel a bit funny going first. I've learned so much from Marty LEDERMAN's analyses on this issue, and Jen Mascott, if she hasn't literally written the book on officers, she's certainly written a long and comprehensive law review article. And David RIVKIN always has interesting and provocative insights on executive branch issues. But I'll view myself sort of as a leadoff batter, trying to get on base for the heavy hitters to bring me around.
Then you can steal.
Let me first tee up the issue. The Appointments Clause provides that what we call principal officers, not a term used in the Constitution, must be Senate-confirmed presidential appointees, PAS officers in the odd jargon that is often used. The Federal Vacancies Reform Act of 1988 authorizes... 98, pardon me. Thank you. Authorizes individuals who aren't Senate-confirmed presidential appointees to serve as acting principal officers. So the question is, is that Federal Vacancies Reform Act in some of its applications unconstitutional. Specifically, the FVRA has three different subsections that provide for three different sets of officers, or individuals rather, to be eligible to become acting officers. The first set consists of the first assistant in the office. The first assistant to principal officers is sometimes himself or herself a Senate-confirmed officer, but sometimes not. The second provision enables the president to designate any other presidential appointee who's been Senate confirmed to serve as acting in the event of a vacancy. And the third, the one that's at play in the designation of Matthew Whitaker, allows the president to direct an officer or employee of an executive agency to serve as an acting officer if that individual has satisfied certain requirements I won't bother to go into here, basically certain level of pay grade and time in the office. The same Federal Vacancies Reform Act provides that these individuals may serve for quite a bit of time, possibly indefinitely under the terms of the Act, but there's an initial 210-day period that's allowed. And then if there are subsequent, if there are nominations, during the pendency of those nominations, this individual can continue to serve as acting. Again, in theory, I think this could go on forever, but at the very least, we're talking 210 days. So when Matthew Whitaker was designated as acting AG in early November, the Office of Legal Counsel issued an opinion explaining its advice that it was permissible for the president to designate him. 20-page opinion. I'm going to run us through it briefly, just help frame the conversation. I should disclose that the opinion relies in part on a 2003 OLC opinion, a much shorter opinion that I wrote, or at least
Succinct, we call it succinct.
that I wrote, or at least signed. You know, have that in mind if you're think I have too much of a tendency to defend the OLC view. Okay, the thrust of the OLC opinion is that all three branches have long recognized that non-PAS officers, as individuals who are not appointed by the president and Senate confirmed, may serve as acting principal officers. A law enacted in 1792 authorized the appointment of any person to fill vacancies in the Departments of State, Treasury, and War, including the position of secretary or head of each of those departments. On at least 110 occasions, the OLC memo explains, from 1809 to 1860, beginning with President Jefferson, presidents used the authority under this law to have chief clerks, not Senate confirmed, temporarily serve as acting secretary. On at least 21 other occasions, there were individuals other than chief clerks who were not Senate confirmed who served as acting secretary of the Treasury. In 26 other instances, there were individuals who served as acting heads without any specific statutory authority, all of which led President Buchanan in 1861 to state that the perfect lawfulness of this practice has never, to his knowledge, been questioned or denied. Now, I wouldn't ordinarily cite President Buchanan as authority for anything, but the question is he right or not? It seems that he's correct on that. Then there was the Vacancies Act of 1868 that eliminated the president's power to fill a vacancy with a non-PAS individual, but at the same time preserved the possibility that a non-Senate confirmed first assistant would serve as acting head without any necessary presidential designation. The Supreme Court ruled in 1898 in the case of United States v. Eaton, which is at the center of much of this debate, that it was permissible for a U.S. consul to Siam who had fallen ill to appoint his vice consul to carry out his duties until the consul successor arrived. This consul position under the Constitution is one that requires, is a principal officer. Mr. Eaton ended up serving for 10 months, later sued for pay for those 10 months. And the Supreme Court ruled that he was entitled to pay, that he had been lawfully appointed. And I'm going to read a couple sentences of its explanation here, as I think we may have some discussion about this. Because the subordinate officer is charged with the performance of the duty of the superior for a limited time and under special and temporary conditions, he is not thereby transformed into the superior and permanent official. To so hold would render void any and every delegation of power to an inferior to perform under any circumstances or exigency the duties of a superior officer, and the discharge of administrative duties would be seriously hindered. So Eaton was not a principal officer by virtue of the acting designation. He could serve as acting head without that designation violating the Constitution. Fast forward, we have this Federal Vacancies Reform Act enacted in 1998. Practice under that, under President Bush, President Obama, and President Trump, includes designations of non-PAS officers as acting principal officers. Under President Obama, for example, there were various, I think some 8 or so White House memoranda that placed non-Senate confirmed chiefs of staff in the line of succession to be acting head. There were 3 executive orders that the OLC opinion cites that placed the chief of staff above Senate confirmed officers in that line of succession. And there were 3 actual designations of non-Senate confirmed individuals as acting principal officers, one of which lasted for 10 months. So on the basis of all this, OLC concludes that the designation of Whitaker is lawful. I'll emphasize that the OLC is agnostic on the question whether someone designated in these circumstances is an inferior officer or is not an officer at all. Let me finish with a couple brief observations of my own. An interesting question here, I think, is how one assesses the question whether someone is serving temporarily. How do you address the question of temporariness? Interesting issue to rise today on the very day on which President Trump has announced his intention to nominate former Attorney General Bill Barr to become Attorney General again. I think many folks a month ago when Matt Whitaker was first designated imagined that he would be acting Attorney General forever. Of course, that was a possibility. But I think there's a defect in the way some have approached this. I would argue that temporariness needs to be looked at in real time, and that service in an acting position might at some point cross a line from temporary to too long to be lawful, but you don't determine at the outset when someone's just been named, if you at least get past this threshold point and accept that some sort of temporary service is allowable. I don't think it's proper for courts or others assessing the legality to say, we think at this point on day one that this person might serve for 18 months, and therefore we're going to say this is unlawful. I think they ought to say no, until you cross that line where that's a fuzzy line, and we'll probably discuss that, the person's service is lawful. And I think, you can imagine a hypothetical involving the Eaton case where, say Eaton had ended up serving much longer than expected. So let's say instead of serving 10 months, he had served 40 months. Would that mean he wasn't entitled to payment for those first 10 months or for whatever the temporary service was that the court found allowable? That seems peculiar to me. So again, I suggest that temporariness is something that needs to be assessed as time proceeds. I'll simply conclude by saying that I think the OLC opinion is eminently reasonable. It's the role of OLC, I think, to take a robust interpretation of executive power, just as the Supreme Court often takes a robust interpretation of judicial power. I think it's reasonable to read the longstanding practice that's allowing for non-PAS to serve as acting for a temporary period. And I also think that judges, courts ought to be very careful in how they approach this issue. I think first, until the temporary window has passed, I think it'd be unreasonable to determine that someone has been appointed for more than a temporary time. Beyond that, I think it's an issue that they should avoid deciding unnecessarily. And given the uncertainty and I think the reasonableness of the OLC opinion, I think, and indeed the position of Congress that this is okay, I think courts should defer to the political branches since there is significant, at the very least, significant uncertainty. Thank you.
Next, Professor Lederman.
So, after a couple days after OLC issued this opinion, Walter Dellinger, who was the head of OLC, I worked for both Walter and Ed at OLC, had the privilege and pleasure of doing both. Walter and I wrote a piece on just security, going through all the statutory and constitutional issues surrounding the Whitaker appointment, and we concluded by saying, effectively, that if President Trump made a nomination very soon, most everyone will stop worrying much about Matthew Whitaker. The lion's share of attention will then appropriately be refocused on the Senate's consideration of the nominee. So I hereby move that we switch this panel, that we shift the panel to the Bill Barr's robust theory of the unitary executive, which is going to be, we may have to convene a panel next week because that's going to be the topic of the next few days and weeks to come.
Motion denied.
Motion denied, okay. Well, like any good lawyer, then I have to pivot back to my original plan, which is to give some, well, let me start with this. It looked, I'm going to, in a minute, agree with Ed's assessment of what ended up happening here, which was sort of a course correction in the system working as it should in some sense, as exemplified by what happened today. The concern here is that even if you think this is technically constitutional, I think there was a widespread consensus that it was what I'll call anti-constitutional, that what President Trump did had been anti-constitutional in the following sense, that it appeared that he was exploiting what might have been a reasonable OLC view, and maybe if it's even the right view, that there is some give in the Constitution in terms of appointing people who are not officers within the department itself to perform the functions of the head of the department temporarily while the Senate is considering a nominee. And I'll get to that in a second, the constitutional question. And what he did, and he's not the first president to exploit this kind of a loophole in the law or in the Constitution, was to say, oh, well, in that case here, I'm not even, I knew months in advance I was going to get rid of Jeff Sessions. I don't have a replacement in mind. I'm not going to name someone immediately when I do remove the Attorney General. Instead, I'm not going to replace him the way attorneys general have been replaced, or temporarily, since the beginning of the virtually the beginning of the Republic, and certainly since the beginning of the Department of Justice, which is there's a DOJ statute specifically about who should perform the functions of the AG in his or her absence, and it's been, until there was a deputy, it was the Solicitor General for many decades, and then after that, the Deputy Attorney General, followed by a succession of other high-level DOJ officials. And he skipped over Rod Rosenstein, not only Rod Rosenstein, but Noel Francisco and Steve Engel and several others in the line of succession to pick someone the Senate had never considered, and someone who looked, to all accounts, to be someone who was much more susceptible to the president's wishes, right? That was more of a lackey, someone who would probably never be confirmed and who would be more loyal to the president, especially in the oversight of the special counsel and related proceedings. And so even if this was constitutional, it was quite a remarkable deviation from the historical norm, whatever the correct view of the historical data correct view is. of the data, in that the president here created the vacancy, did not immediately announce a new nominee. I'll get to that in a second, whether there's any historical precedent for that, and deviated from the congressional expectation of this particular statute involving the Attorney General. Thereby, it seemed like he was trying to circumvent the role of the Senate. And this precipitated just, I think, actually quite a bipartisan and quite broad criticism of the president. And his lawyers are probably telling him there's some chance the courts will hold that this appointment is unconstitutional or illegal under the statute. And for that matter, it's going to potentially call into question the legality of a lot of things that DOJ is doing in the meantime. Do you really want to run those risks? This is not a good idea politically or legally, leading to today's announcement of the nomination of Bill Barr. The one historical analogy is after the Saturday Night Massacre. It took President Nixon 13 days to announce that Senator Saxby would be nominated to be the replacement Attorney General, and about 35 days to formally send up his nomination to the Senate. I hope that President Trump, we're sort of in this lame duck period, but so I assume it'll be the new Senate that considers Barr for Attorney General, and I hope the nomination is up before the Senate by January 3rd, as it should happen. Now the ball's in the Senate's court, as it should be. So the system sort of worked to counter this, what I'm calling this anti-constitutional, even if it's not unconstitutional, move by the president, which I think we all ought to be inveighing against. So as to the constitutional question, I'll make a quick point about the pre-1868 history, and then a couple thoughts about the constitutional question itself. I think it's a hard question. The history is not nearly as supportive of President Trump as OLC suggests. The vast majority of these cases before 1868, something like 80 or 90% of them, involved one of two things: either a temporary, the head of the department was out of town or ill, but actually had the power to superintend and countermand the decisions of the acting person. It wasn't an actual vacancy, or it was done during a recess of the Senate when the president had the recess appointment power anyway. So that leaves only a handful of cases, and it appears, we're not certain yet because no one's dug full down yet, in virtually every case that happened before the original Vacancies Act of 1868, it was a case in which there was no Senate-confirmed officer in the department, high up in the department, who could be said to have been vetted by the Senate already for the possibility of such acting role. I'm not going to get into the weeds on that issue, but there's no appointments clause problem if acting as the Attorney General temporarily could be said to be germane to the office for which the Senate did confirm the person. That's fairly well established. It was just a choice between either appointing someone who the Senate had not confirmed or someone who the Senate actually confirmed for another department, or not have the statutory authorities performed at all. And that's Eaton. That describes the Eaton case. It's a case in which, and I think all of the cases in the 19th century, in the late 18th and the 19th centuries, are all cases in which the only choice was to choose someone who the Senate had not confirmed or had confirmed for a different department. So what does that mean? So there was that practice. It's much smaller than DOJ suggests, but it was there, and it certainly was contemplated in the statutes that acknowledges Congress enacted beginning in 1792. What does that tell us? Well, one of three things, and this is all in our post. First possibility, which I tend to think is right, and I'm interested to hear what Jen has to say about this, is I think that most people in the late 18th and the 19th centuries thought that truly temporary, that usually just for just a few days or a week or so, these sorts of temporary substitute teachers, as it were, right? Just people filling in. They weren't even acting, they didn't have the office. They were just performing the functions and duties for a few days. Did not make them an officer or a new officer at all. They weren't officers. There was a general principle that transient performance of even transient filling in of a role of an officer did not make one an officer. That's why, as far as I can tell, and I've only begun to scratch the surface, but I've looked at a whole lot, the appointments clause question was just never raised at all. It's not like people raised it and said, gosh, we got to do something about it. It didn't occur to anyone, or very few people, I think, that this was an office. That's possibility number one. Possibility number two is the one most people are talking about, which is that somehow a temporary officer is an inferior officer, and therefore Congress can authorize the president to appoint an inferior officer. Appointments clause mavens out there will know about that. I don't think that's right. I don't think that makes any sense, and I don't think that's what the court said in Eaton. So the third possibility is what I think the court did in Eaton, which was to say, and this sort of conforms to the practice in the first 100 years, the Constitution has to be read pragmatically, right? There has to be some play in the joints for cases of true exigency. What the court said in the Eaton case was that it was not only for a limited time, but under special and temporary conditions, lest the discharge of the principal officer's duties be seriously hindered. Where that is the case, where there's no choice except between having the duties and functions not performed at all or appointing someone, I guess, outside the appointments clause, the court said unanimously, who cares about the technicalities of the appointments clause? The Constitution should be read as a pragmatic document. And that's a unanimous decision. I think that, and possibly the idea earlier, before 1898, that it wasn't an office at all, those notions seem odd to us now, especially maybe to many people in this room for whom the Appointments Clause and other formalist and textualist views of reading the Constitution have become de rigueur, or very sort of the coin of the realm, and I just don't think that's how most Americans, justices, judges, executive branch officials, and Congresses thought about these things for most of the first century of practice. And so I do think that Eaton stands for the proposition that where there's true necessity to not appoint someone, you can do this for at least a temporary period with the obligation to quickly nominate someone, which is what OLC said in a 1977 opinion. The president has a constitutional obligation to get someone up before the Senate. Here, there was no exigency. Rod Rosenstein would have performed the functions of the Attorney General automatically if Donald Trump had never lifted a finger. He didn't need to go to Matthew Whitaker. One final point, which is just that it's a pleasure to be here with Ed earlier, with Todd. When you work in the Office of Legal Counsel, probably about 10 to 20% of your docket is the appointments clause, although it seems like 80, right, Ed? Something like that. And Jen has had the audacity to sort of tether her career to the appointments clause. God bless her. And all of a sudden, this is like, these are salad days for the appointments clause. It's everywhere. There's appointments clause litigation about whether Robert Mueller's appointment was constitutional, about whether Matthew Whitaker's, and there's great litigation just argued this week in the First Circuit about whether the appointment of the Puerto Rico Bankruptcy Board, the PROMESA statute, is constitutional under the appointments clause. So it's finally paying off for us LLCers and Jen. Everyone wants to know about the appointments clause, so we're being invited to lots of panels.
And now my audacious colleague, Professor Meissner.
Well, yeah, that reminds me, I should thank Marty, because Marty early on, and I had a nice conversation in the hallway about.
Did I tell you, tether your career to the appointments clause?
No, but you did point me to some of your research that you've done, I think, at OLC, and so I appreciated you taking an interest early on, I think long actually before the paper was published, and indeed, when I was a fellow at Georgetown, there were many people who generously gave of their time, so that was just a really great experience and kind of incubator for me to write this apparently audacious paper that I wrote. And also, I was just going to also preface what I said with, actually, Adam had to sort of twist my arm, if this is okay for me to say, to come today, because with that paper, I had spent an awful lot of time dotting I's, crossing T's, doing a real thorough analysis of the question, really, of how significant does one's duties have to be before one rises to the level of officer of the United States. I've not done anything like that with my own sort of research on the separate question that I think we're talking about today, which is, does serving in such a position temporarily, or being maybe a temporary custodian, we might think of it, of some of the duties of that office rise to the level of being an officer of the United States? So normally I would not want to be up here stepping in on something that's become quite a high-profile, fraught issue without having done more research, but I will just maybe highlight a couple of points that I did stumble across in my research of the other project that might be relevant here. And I'm also going to pivot a little bit at the beginning and just throw out a couple of thoughts. Marty raised this point of maybe this appointment wasn't unconstitutional, but was anti-constitutional. And so just to kind of play devil's advocate, I think one of the things you said is maybe the president picked Mr. Whitaker because he would be his lackey. And so I mean, I think at least with the Attorney General, we still consider that an executive office. And so generally speaking, we actually would want it to be somebody who's going to carry out the president's duty. And just thinking about it, I mean, I guess I don't think we know enough to say that this was just some contrived appointment, because another reason you might want the chief of staff of the gentleman who was formerly in the office to be there is perhaps one might think that the chief of staff in a temporary way would actually carry out the former attorney general's mission and be sort of faithful to that and continue that on. And perhaps, you know, by doing this also, we've allowed the other folks who were in the positions that Marty mentioned as possible replacements, Rod Ozenstein, Steve Engel, Noel Francisco, to continue to do their job and also serve the department and just have somebody else in that role. So the real question, I think, is not whether this is somehow anti-constitutional, but is it unconstitutional? And I do think Marty and Ed and the OLC memo and a lot of other folks analyzing this are pressing on the right point. I mean, obviously the question is not really whether there can be an exception to the appointments clause, but does the position that Mr. Whitaker's serving in right now rise to the level of officer of the United States? And I think, I think certainly with the historical practice that OLC has uncovered, there's a lot of strong evidence in that historical practice to the extent that one thinks that's a valid way to try to get at the historical meaning of the Constitution. That I think actually, along with Ed, is actually quite compelling. Now, I don't think that looking at the historical post-ratification of the Constitution practice is quite doing an original meaning analysis. I don't know if anybody's really done, to this point, a pure, thorough original meaning analysis of what were the framers' understanding going into the Constitution. I think that's partly because I don't think actually the framers did spend a lot of time discussing some of these subsidiary issues. You know, when they were going through the drafting and ratification debates, they were looking at much larger scale things, like how many terms can the president serve? How are we going to select members of the House and Senate? There's just not a lot of discussion going in about precisely what the phrase officer of the United States meant, or this issue of temporary service. I do think at least most judges now would find it highly relevant what the practice has been for, you know, over 200 years. And so as Marty and Ed have pointed out in the OLC memo, there was the 1792 Vacancy Act, which right from the Second Congress basically said in the case of death, absence from the seat of government, or sickness of the Secretary of State, Secretary of Treasury, Secretary of the War Department, or any officer of any of those three departments, those were the only three executive departments at the time, whose appointment's not in the head thereof, if they can't perform their duties, it shall be lawful for the president to authorize pretty much anybody to serve in a way that he seems fit until the absence or inability by sickness shall cease. And then several years later, the Third Congress made a couple of amendments to limit, principally the change was to limit the term to 6 months. So perhaps there's some idea early on of what people thought was a reasonable limitation. It's actually not all that different from the time limit that we have now in the Vacancies Act of 210 days. And so I think while Marty's pointing out that no, there are not a lot of examples that the OLC cites that are precisely what we have here, where we're talking about the Attorney General resigning and this precise factual circumstance occurring. I think generally, I mean, my understanding has always been of when we look at early practice, the early practice here, I think one way to conceive of it is not what specifically were the vacancies and what was this precise factual scenario they're happening to fill the office, but it might have been more the early practice is that Congress seemed to think that this statute was constitutional, and the statute itself, again, does not seem to limit the replacement to being a Senate-confirmed person. There's no limitation that the Secretary of State or Secretary of the Treasury being replaced had to be close by and just handing out responsibilities. And so to me, the early practice, even if you can't slot specific factual scenarios into it, seems as though Congress back at this point in time was thinking very broadly. I mean, one counterpoint I think some folks might bring up is, well, the government was a lot smaller back then, so maybe there wasn't this specificity that you have to have a Senate-confirmed person serve in one's stead because there just weren't that many people to choose from. I think that's actually would be incorrect. I mean, there were not a lot of officials going down in these executive departments, but there were quite a few Senate-confirmed officials because there were more than 100 customs officials. There were collectors and surveyors and naval officers, they were called, who were confirmed by the Senate. So there would have been a stable of people to choose from, and for whatever reason, Congress did not put that stipulation on people serving temporarily. I think actually what Marty said, the first option's probably right. I think he's right that to the extent Mr. Whitaker's doing anything at all, it would not be to serve as an inferior officer. I don't think that just taking on something temporarily changes your relationship in terms of whether you have a supervisor between you and the president or not. I think if that's constitutional, it would be just because the framers would not have thought people serving as kind of a temporary custodian actually held the office at all. So I don't think anybody could really make the claim that somebody who's not confirmed by the Senate could actually hold the office of Attorney General. I don't think that's what anybody's claiming. I think it's just that you can serve perhaps as a temporary custodian, and then as Ed pointed out, the question would be, when do you switch from being a temporary custodian to actually looking like somebody where we're trying to kind of they're actually now switched into being an office holder, and we're trying just to get around constitutional requirements. The other thing I wanted to mention is I think, everybody's talking about the 1792 Act, and that's the one that's most on point because it was talking about vacancies in the head of departments. But actually earlier even than that, in a 1790 statute, there is an example of a succession plan that I think also perhaps suggests that, and gives more evidence to the idea that at least the first Congress thought not everybody temporarily serving in roles were officers. There was this big category of deputy officials. There were deputy marshals. There were also deputy customs officials who were people who were not necessarily prescribed to be appointed even as officers, much less as principal officers. And so the customs collectors, the customs surveyors could name deputies temporarily to do certain things. And Congress was actually quite specific in the statute, which I think also shows that Congress knew how to be specific when it wanted to be, even about succession plans then, which would, make me hesitant to want to add any more constitutional requirements onto the text of their 1792 Act. But it was very specific. It said, the 1790 law, every collector, naval officer, surveyor, if they're occasionally absent, if they're sick, they can assign a deputy to do their duties. And then Congress had something different to say if a collector had actually died and wasn't around any longer at all. And in that case, the collector's duties would go in line to the naval officer, then to the surveyor. And if there wasn't such a person, or if the surveyor died, then the collector could nominate somebody else. So here again, we don't have somebody with the import, obviously, of the position of the Attorney General, which I think Marty, in his pieces, is suggesting perhaps is a relevant distinction. We don't have a lot of examples of somebody with that vast power being put into a temporary spot without Senate appointment. But we do have these examples early on where, again, Congress does not seem to have any trouble with people without any constitutional appointment at all taking on temporarily these other governmental duties for these people who were in their own Senate-confirmed positions. So it's not perfect evidence, but I think it just does seem to have been a pervasive understanding at the time that people could temporarily be custodians and were not actually holding an office themselves. They were just serving on behalf of somebody else. The one other point I would mention before Adam cuts me off is it might, as Marty said, seem strange to us. Why would this be the case? It seems like perhaps we're trying to get around what I argue in the my Stanford paper is a very significant constitutional constraint, and I think that it is. I mean, I think having the accountability of the appointments clause is a very important constitutional constraint for principal officers, as Ed and Marty have mentioned. They need to be appointed with Senate advice and consent. For inferior officers, which in the paper I argue is the vast run of the federal government. So with all this newfound interest in the original meaning of the appointments clause, I welcome everybody to look at all the other folks in the government we can be applying these constraints to. But one other way possibly to conceive of the whole constitutional structure, which I'd be interested in getting everybody's thoughts on, is I think in researching a couple of papers that at least at the very beginning, the first plan that was thrown out for the constitutional structure was this very abbreviated Virginia plan that actually did not even have a provision for the appointment of executive officers at all, even though it had a provision for how we would appoint, how judges would be appointed. And there seems to have been an understanding, I think, under the earlier Articles of Confederation, that it was inherent in the executive function to be appointing executive officers. So one reason why there might not have been all this specificity and not all this controversy is because if there was a background understanding that generally the executive power included the appointment and then the removal of executive officers, how we would see the appointments clause would be a very specific, particular decision of the framers and ratifiers to then subtract from that power in the particular textual way that's specified in the appointments clause. So when you have a principal officer, when you have an inferior officer, what basically the framers were doing is saying, we're not going to go with the default separation of power structure of each branch doing their own thing. We're going to give Congress a very important role here in requiring them to establish offices and in some cases require Senate consent. And but I think if you have that conception, then you need to call somebody officer of the United States, they actually have to fall into that. They actually have to fall into that category. And there may have just been this background understanding that generally we think in the past it was okay for the executive to be appointing these people. And so if there was at some point somebody in this position who was confirmed the proper way under the appointments clause, it wouldn't be that audacious to think that temporarily the president could go with that default executive power of putting someone in to stopgap and not really hold the office, but just be a custodian until such time as the office was filled. And one last thing I would encourage people to look at, on the Originalism blog, run by Mike Ramsey and Mike Rappaport, they actually both think the Whitaker appointment, I think, is unconstitutional, but they have another blogger, Andrew Hyman, who I do not know, but he's the only person I've actually seen who has kind of a unique piece of pre-constitutional evidence that might explain the 6 months. He has a post where he talks about the Giles Jacob Legal Dictionary going through in the mid-17th or 18th century and talking about the practice of offices in Britain. And actually, in this definition of office that he digs up, there's a provision under British practice where if the king dies and there's nobody to appoint replacement officers, that folks can continue in that position for 6 months. So he posits maybe that's where that figure comes from. As I say, I have not done what would have to be extensive, I think, research to figure out if that's correct. But those things make it seem to me like it's at least highly plausible that indeed the framers did have an understanding that there could be acting folks who were temporary custodians and did not actually rise to the level of officers at all.
Well, thank you very much. And now, finally, thank you for joining us again, Mr. Rivkin.
It's going to be somewhat ironic since I'm the only person on this panel who has not served at OLC, but I'm going to be serving the White House counsel's office, but I'm...
Jen, just pretend. She
Oh,
could.
I've never pretended.
She should.
What I was going to say, I'll take an even more robust view than Jennifer, although I have to say I am cheered by her presentation because in a couple of points she made, I would make the same and would reinforce them. But I first cannot help myself. I want to take something off a table. I personally don't think there's something that's anti-constitutional. Something is either constitutional or not constitutional. I think all the concerns and anxieties about Trump, whether you call them policy preferences or Trump derangement syndrome, should not inform my analysis in the slightest. I'm also not a fan of a pragmatic reading of a Constitution. So whether something is exigent or not exigent does not inform at least my interpretation of either how the Appointments Clause works or anything else in the Constitution works. Let me try to be controversial now and say this. This has nothing to do with executive power. This really is about the scope of congressional power, because the Appointments Clause is fundamentally about limiting the ability of a president to fill the executive branch with individuals solely of his choosing. So it is really about cabineting the executive. When it comes to Appointments Clause cabineting of Article 1, it is exceedingly slight, in my humble opinion, as a simple examination of the language of Appointment Clause would point out. And I
totally agree with Jennifer. There's nothing in the Appointments Clause language which prevents Congress operating on its enumerated powers, which there are several. Taking NNP aside, you got power to prescribe rules for the conduct of government, you have power to create governmental structures and offices. Nothing that prevents Congress from reaching a conclusion that an individual who is encumbering a congressionally created office that would be filled by a principal officer, if it does it in temporary capacity, it's a different animal. And that, by the way, is indeed, to reinforce probably somewhat more robustly the point made by Ed. If you look at the Eaton case, in two different places, the court says we do not buy this functional transformation argument because the vice counsel, who may call an officer, performs exactly the same functions while he's doing that as a counsel, but it doesn't make him a counsel. So to the extent Mr. Whitaker performs exactly the same functions as acting attorney general, that would be performed by a principal officer attorney general does not make him the principal attorney general. So to me, this is one of the easiest constitutional questions. Nothing prevents Article 1 from deciding how it wants to exercise its enumerated powers and decide that somebody performing in that capacity, as a matter of common pragmatic sense, you certainly don't have the same heft in the interagency process. You don't command the same influence of your peers or the media or the American people or the president for that matter, that you're just a different animal. And Congress could slice it in a variety of ways. It could decide that that person is an inferior officer, in which case can be appointed by the president. It can decide this person is not an officer at all. Or it could decide that this person has to be a principal officer. Now, there could be some structural separation of powers concerns in terms of impairing the ability of the president to carry out his duty to execute the laws faithfully. Congress created all sorts of agencies and departments and insists, which I think it can, at least in the first instance, that no matter how short unexpected the vacancy is, you got to have a new principal officer in place. It's entirely the case. So it is all about congressional power that is trammeled very, very little by the Appointments Clause. I don't understand the argument there's something magical about the AG. Maybe Marty can explain it better. That I don't understand the argument the Secretary of Treasury or Secretary of State in its sphere exercises lesser power. In any case, it's a pragmatic argument which I don't think has any particular constitutional cabining. And what are we supposed to take a different view of how the Appointments Clause applies here because the Department of Justice has not been created for a long time after the founding? It makes absolutely no sense to me. And the whole discussion about exigent circumstances, I see nothing about exigent circumstances in the Constitution writ large, despite references from time to time it is not a suicide pact. I see nothing manifesting linguistically exigent circumstances in the Appointments Clause or in Article 1. I don't think it makes any difference. Now, to be fair to Marty, yes, there's a discussion in Eaton about exigent circumstances, and I can find a discussion on exigent circumstances in many other cases, okay? Structural separation of powers in particular have been decided by reference to what I think a fundamental constitutional principle. I can find you exigent circumstances discussion in Youngstown, and I can find you that discussion in Curtis Wright, the president is always right. Courts do it all the time. I would not derive any great significance from that. So Congress can slice it, again, short of incapacitation of a president, not enabling him to continue to run the unitary executive and comply with his obligation to execute the laws faithfully. Congress can slice it any way it wants. Why this has been viewed as something that has to do with exercise of power by President Trump, who's done exactly what Federal Vacancies Reform Act allows him to do is, I mean, to me, very difficult to explain with any legitimate constitutional considerations. Thank you.
Too quick.
Well, a lot's been said since Ed and Marty went first, so why don't I at least give those two a chance to respond to what's been said after them.
Well, very briefly, I guess I have a couple points in response to Marty. I mean, I would see anti-constitutional, if Marty uses that label, is really talking about political objections, and obviously politics properly constrains what happens in the real world, and one need not adopt Marty's account of why President Trump did what he did to recognize that other people do adopt that account, and it does condition the process in some way. I'm skeptical of Marty's claim that about history, in part for the reasons Jen already went over, but in part, let me just, like, even if the 160 examples are down to 30, that's still a lot. You have this congressional legislation that reflects this understanding. And in particular, I want to resist Marty's claim that because some of these designations were made during recesses, that means they were exercises of the recess appointment authority. You would expect that when the president is exercising the recess appointment authority, he would spell out that I'm appointing you until the end of next term, whatever the exact language of the appointments clause, recess appointments clause is. I haven't seen any evidence that happened.
Two quick things that I probably left misimpressions on. One is that I didn't mean to say that they were all. A few of them apparently were. Others, Tom Goldstein has done the work. I haven't on that. Many of them could have been, and the point I was simply making was that they were typically done in a way that didn't occasion anyone having any problem. But more importantly, in virtually all of these cases where you had actual death or resignation, there's almost no cases of firing before the attempted firing of Stanton as Secretary of War by Johnson in 66. In 68, sorry. The president would immediately nominate or name a replacement, and put it in the Senate's in the Senate's lap, which is sort of how it should be, and that's what I was suggesting would have been anti-constitutional. I actually think today's developments are very salutary and good and not anti-constitutional. And the other thing, I didn't mean to suggest that there's any special rule for the AG. I don't think there is. So on the question of whether, I don't know whether the early Congress's presidents, others thought this simply wasn't an office, but if they did, it was because of those factors. It was just a few days. It was until the Senate could act and the like. Or whether, as the court in Eaton suggested, we'll just read the Constitution pragmatically, and so where there's truly a necessity of carrying out the functions of the head of the department or a counsel in Eaton, we just won't be so precise as to require absolute compliance with the Appointments Clause. That's not a type of constitutional argument that David is particularly fond of, and I haven't stated any position here on whether I think it's right or wrong. I do think it was common and uncontroversial for most of the nation's history to think about the Constitution in that way, whether you think it's right or not. And then finally, I actually agree with David on an important thing, which is that what Congress has to say about this, how Congress chooses to fill these vacancies, should have a very important impact. We consciously decided to focus here on the constitutional question, but most of you in the audience probably know there's a very serious question whether this is a proper reading of the Vacancies Reform Act that gives the president this authority. I actually think it's a very close question. I think it wasn't the intent of the Congress in '98 to supersede this law that had been in place since 1870, in which Congress specified who would take over the powers. That is what's special about the AG, is that there's an AG succession statute that had always been followed. I don't think the Congress intended in 1998 to undo that, but I do think that maybe some folks in DOJ sort of snookered the Congress, or the language and the evolution of the language in '98 allows for OLC's argument, and it's not a ridiculous argument, that if you look at the text of the statute rather than the congressional intent, perhaps it allows the president to use the Vacancies Reform Act to supersede the AG succession statute. But that does result in some anomalies. For instance, that both Rod Rosenstein and Matthew Whitaker now have the legal authority to perform the offices of the Attorney General. Or in the case where if Trump hadn't done anything, would Rosenstein's appointment be as acting be unlimited in time under the AG succession statute, or would it be limited under the Vacancies Reform Act? You would sort of be at loggerheads. And so what I've argued online is that the difficulty of this constitutional question, on which I haven't settled for an answer, ought to counsel in favor of reading this difficult statutory question in favor of not giving the president this authority to supersede the specific choice that Congress has made since 1870 to have the second in command at the Department of Justice be the one to fulfill these functions. So it's the avoidance canon that I'm relying upon.
David, were you about to say something a moment ago? I thought you were
Yeah,
going to push the microphone.
just a couple of things. No, I agree with Marty. There is a lively debate about whether Section 508 is the right statutory vehicle versus the Vacancy Reform Act. I just don't find this debate to be particularly exciting.
Unless you're an OLC.
Well, I mean, I'm familiar with legal arguments. I think it's a close call. By the way, I don't think conceptually the constitutional avoidance plays particularly well in this effort to harmonize the two statutes. I mean, the constitutional avoidance typically plays out in the context of a particular statutory interpretation, where the two interpretations of a given statutory language in the same statute, and you adopt the one that may be even a bit more strained, but presumably still within the sort of a broad Chevron zone, to borrow the word from another legal lane, in order to avoid the constitutional question. But I kind of want to go back a little bit, again, to what I think is the most fundamental here. Look, I understand pragmatism. I understand that practical considerations and exigencies matter. But maybe I should rephrase my initial point by saying, you go there when you absolutely have to. You don't start with that. To the extent that there is a perfectly sufficient constitutional language in the Appointments Clause, and again, remembering what it's there for, and then you balance it with Article 1's formidable authority, the structure of government. Article 1 decides in its infinite wisdom, as Jennifer and I have both said almost in identical words, that if you are encumbering an office in a temporary capacity, you're not an officer at all, or we decide you're an inferior officer, I see precious little to inform the argument on the other side. We don't need to resort to pragmatism. We don't need to resort to making things work. That's point number one. Now, I understand, by the way, that they can be difficult questions. I'm inspired by it with some of my own younger colleagues that, as Ed points out, under perfectly plausible interpretation of Vacancies Reform Act, you can have an infinite successors of acting officials. So can Congress, in entirely wholesale fashion, override for a statutory vehicle the Appointments Clause and basically say it doesn't matter how many times we can have an acting person in this position, we're just not going to bother, even though it's an office we created as a principal office, we're not going to bother with Senate advice and consent. And one of my younger and more impertinent colleagues who likes to spar with me as I prepare for argument said, if it's an oral argument, what's your response, Mr. RIVKIN? And it's a tough response. But these are, and I made a note when I heard Ed talk about this issue, that you don't do it at the front end. What it means in litigation terms, these are always applied challenges. These are not facial challenges. You do it as applied challenge if somebody like Whitaker encumbers, assuming Trump wins the second term, which is far from clear, encumbers the AG office for 3 times 210 days. Yes, and I'm perfectly aware there's some limitation on congressional ability to prescribe for the officer, as well familiar with the case law relative to SCLJs and many other things. But Congress has tremendous flexibility here in dealing with this issue. And again, to me, leaving aside all the politics, it's kind of stunning to have all Senate Democrats sue of this matter, leaving aside issues of legislative standing, but are dear and near to me. They're really suing themselves. They're trying to say there's constitutional cabining by virtue of Appointments Clause of Article 1's authority to deal with this issue. They're really not kicking Trump. And there's just an enormous irony here.
I do want to lob just 2 questions at the panel before we run out of time. There are legal doctrines, I'm thinking of the de facto officer doctrine, where the law sort of understands, or parts of the law understand, that sometimes an office exercises power without a legitimate occupier of the office, right? The court holds that, no, this person did not legitimately occupy the office, but the action that person undertook was still lawful because it was under color of law. That's my understanding of the de facto officer doctrine. And thinking about that in this context, I wonder if maybe metaphors are important. We talk about an acting officer, we talk about somebody occupying an office, somebody encumbering an office. Maybe that's just totally the wrong way to think about this. Maybe this is just a case of somebody within the department, somebody near the office, or somebody operating under the person who held the office, who's wielding the power of the office, I guess this gets to your point, without actually occupying the office. Where I'm going with this is, does an office have to have an officer, right? Can't we just say the office is vacant, somebody is wielding the power of that office, but they're not acting as that officer, they're not occupying that office?
Well, that in fact is the
What-
language of the
what-
Vacancies Reform Act. And we're using the shorthand acting officer, which I guess is the shorthand in the title of the Vacancies Reform Act. The actual language is, shall perform the functions and duties of the office temporarily in an acting capacity.
Yeah. Well, I wonder, but, I mean, it kind of reminds me of, one of my favorite opinions is Scalia's dissent in the line item veto case, where he says, you're all falling for a head fake. It's not a veto, right? I know Ed likes this, being Scalia. It's not a veto. It's just terminology is tripping you up. And I wonder if the constitutional issue that's been raised against, in this case, again, I mean, this isn't a panel about Whitaker, but it's he's the one who's at issue these days. I wonder if we weren't calling him an acting officer, if we weren't saying he occupies the office, if we were saying the office is vacant, but the office still has power that can be wielded by people in government on his behalf, if that might change the way we think about the constitutional issue. Professor Mascott, were you going to say something? Oh, no.
Well, I mean, I think that's probably right. I mean, I guess without having done the analysis, I don't know, which makes me think, though, that there's probably then some, if you're just a temporary custodian, there probably are some limits on that we just, like, there's got to be a length of time, or somehow it would seem to me that there's got to be, what is it that makes you just a temporary custodian as opposed to the officer itself? I mean, with the customs officials that I brought up when they had this deputy role, and my paper talks about this more in depth, there was actually a liability relationship that the deputy had with the officer, which actually I think would support what you're saying, whereas it was more, they were just sort of serving in the office without becoming the officer, because if the deputy did something and was sued, they would actually sue the estate or the principal officer themselves. And so I don't think they actually did hold the office. It was always in the principal. I don't know what the constitutional implications are of, does that mean there's any way in which the person who's serving as a temporary custodian needs to be limited? Maybe it's just time, maybe it's something else. I don't know if you all have thoughts on
This is very interesting, because when you think about it, about 99% of the functions, statutory functions of the Department of Justice are vested in the Attorney General. Obviously, whoever it is, right, Eric Holder or Jeff Sessions or Matt Whitaker or Bill Barr does not perform 99% of the functions of the Attorney General. Congress also enacted laws giving broad discretion to the AG to delegate all of those statutory authorities to thousands of DOJ officials and officers and employees, which is how the Department of Justice works. Now, of course, that's all subject to the AG's supervision and ability to countermand what those folks say, and that becomes the problem here, right? Because there's no one but the president between the acting person. And that leads to, since I'm trying to bring this back to Bill Barr, right? The impulse among many, but not all, Barr, Scalian, FedSoc sort of folks is to say that the point of the Appointments Clause is to prevent the exercise of significant federal governmental authority except by people who have been appointed in conformity with the Appointments Clause. And that actually is one of the 10 principles that Bill Barr promulgated in early 1989 as he was leaving OLC. That was so controversial. It was a position based on some language in Buckley that any exercise of significant governmental authority had to be cabined by the Appointments Clause, which the court has never said. There's another requirement articulated in Lucia and in Freytag, and certainly in the early history, which is this idea that no, plenty of people, key relators, arbitrators, lots of folks can exercise significant government authority without any Appointments Clause problems. The Appointments Clause only comes in when the person is holding a continuous office that has some sort of temporal extension or that isn't transient. Now, obviously, that's very vague and ambiguous what that means. That's sort of what Jen's getting at. When does it become a duck, right? When it's been quacking and walking and talking like a duck for a long time, can you still call it just transient or temporary or acting? When does it become the thing itself? There's no metaphysical answer to that question. There's no line at which dawn turns to dusk or whatever that famous phrase is, but you can tell one from the other. But at the margins, it's kind of hard. And fortunately, because of today, we might not have to figure out where that line is drawn.
David? Just wanted to say, I think it's interesting, and Marty more or less made the same point, but all of the difficult analytical exercises by OLC relative to what is significant federal authority, Freytag, Lucia, and other pieces of litigation have all been driven by sort of a functional analysis. What is it that you're doing?
But not Barr's memo.
Yes.
Barr's memo was much more formalist.
Correct. But the unique thing here is, what is the constitutional, and look, to say that all federal significant authority has to be exercised in conformance with the appointments clause begs the question of what are the restrictions of appointments clause. And I think the best way to reconcile it, and I agree with you, Adam, whether you call it acting, de facto officer doctrine or not, what is in the Constitution that prevents Congress from taking the position that there's one area where the sort of a functional analysis is different because there's something unique about temporary people. We all know that being, a temporary professor, being a temporary, executive at whatever level of government, there's just something that saps your authority in very unique and distinctive ways. And to say you're just a different animal. Now, it only leaves us, I think it reconciles the historical practice, it reconciles the language of Eaton, it reconciles the language of Federal Vacancies Reform Act. And by the way, let me just say one argument I would have liked to put on the table for a longer period of time is Congress knows very well in other contexts what acting is and what is not. Look at the language of the 25th Amendment, for example, where somebody becomes president versus somebody who performs the duties well, et cetera, et cetera. So that's an old area. And, what is, and that leaves us only but one difficult issue. If Congress delegates too much of a duration to somebody or a series of somebodies to semi-permanently evade the requirements of the Appointments Clause. That's the only question I don't know the answer to, except maybe to say, but it's a Weasley answer, that is PQD. Because what's the ability of Article 3 to determine whether 3 times 210 is too long, but 1 time 210?
Oh, they're good at it. In no canning, they pick 10 days.
So we have just a minute left. I just want to throw one more thing out there, because actually, I liked Marty's, your term anti-constitutional, because I think I know what you mean, and I think I agree, right? That something might be consistent with the terms of the Constitution, at least what I think you mean.
The letter, but not the
Not the
spirit.
letter, but, that's right, that it sort of goes against what animated it.
Jim Caesar at UVA has talked about political constitutionalism versus legalistic, so I think, or
But I
about
was-
constitutional norms even. But
So I was thinking about Federal 76 last night and thinking about today's panel, right, on appointments. And at the end, we talk about the Appointments Clause is important because of accountability, and Hamilton stresses also Senate confirmation is important because of stability, right? By putting the Senate into this, it acts as a check on the president that will promote stability in government. And maybe if the creation of the Vacancies Reform Act and these other statutes makes it easier for presidents to temporarily fill offices, it really reduces the pressure on the president and the Senate to nominate and review and hopefully confirm people quickly. I mean, maybe, Marty, maybe the answer is we need to radically strip back these statutes, right? Take out these escape hatches so that politics would act, the hydraulic forces of politics would actually force presidents to act quickly, force the Senate to act quickly, or to go to recess
I think
appointments.
it's really hard. I think there's pragmatic considerations on the other side. In a polarized partisan world, what if you have gridlock? You want the government to be able to run. So I actually think, obviously, the one thing everyone agrees on is that the Vacancies Reform Act needs some amending. But again, the devil's in the details.
Yeah. Well, on that cheering note, I do want to say, first of all, thank you all. It's been a long day. There are coffee mugs outside. Please take them so I don't have to carry them back up to my office. Please take a coffee mug.
Is there coffee?
I think we're out of coffee, but I will buy you a coffee, Marty.
No.
Thank you very much for joining us, and thank you to our speakers.